welcome to Crime in Court. My name is Heather, and this is episode 31, as you can see, of the Canton Cover-Up Commonwealth versus Karen Reed and Aiden Turtleboy Carney. Yes, it is pronounced Carney, not Kearney, and Judge Bev knows that, but she continues to pronounce it incorrectly. This is an episode devoted totally on Turtleboy. We're going to talk about the fact that he got kicked out of the courtroom. Basically, Friday, court was just in session. Julie Albert had taken the stand again for her cross. And in between Julie Albert and Brian Albert coming to the stand, they stopped court just so they could have a hearing regarding Turtleboy, who finally got his press credentials through the Norfolk County. He got his press credentials, and he did it the right way. He did it appropriately. He did it with his lawyer, Tim Bradl, and he was ready to go to court. He even had to, save a seat and deal with another person that I don't even want to say his name, that is just completely off the rails. If you know, you know what I'm talking about. And so Turtleboy had reserved a seat overnight in the courthouse. He's like, I'm gonna be there the day Brian Albert is on the stand. Well, guess what? He didn't get to see Brian Albert because that's right where they stopped court and had this little hearing. We're going to watch it first, and then we're going to read through the Commonwealth's motion to exclude an individual charged with witness intimidation in connection with this case from the courtroom during the testimony of certain witnesses. Yes, the Commonwealth went to all this trouble to kick Turtleboy out of the courtroom when they are still not even able to prove their case. Like, all that work, Lolly, that you put into this motion, you could have spent working on presenting a better case or cleaning up inconsistencies in your witness's testimony. But no, instead, you're focusing on kicking out somebody and suppressing their freedom of speech right there live on camera. This really, if you've watched my channel at all, I started this channel because of the fact that they tried to suppress Turtleboy's First Amendment right by throwing him in jail. And so that's when I started my channel, after he got arrested. And so I'm going to cover him, and I'm going to cover Karen Reed, because this case I've been I've been following so closely too, and it's insane. Anyways, so let's watch this little brief clip of a little back and forth regarding why they think Turtleboy should be thrown out. Adam Lawley's going to present his case, and you're going to find out too that Adam Lawley never served that motion to Tim Bradl, but they served it to the Associated Press. So, Tim Bradl comes in hot and spicy. So let's just watch this. Let me make sure you're unmuted here. Well, let's go. I have it on 1.25 speed, but you guys should be good. It's understandable, I think, and I'll put the subtitles there, which I don't create. Those come from AI.
The Commonwealth, Your
Honor. Sarah McLaughlin for the Commonwealth.
Good morning.
Good morning, Your Honor. Timothy Bradl on behalf of non-party Aiden Carney, who, for the record, is present in the courtroom.
Real quick. So Timothy Bradl is Aiden's attorney. He has been representing him throughout the whole the bogus witness intimidation charges, which came from like a rolling rally that he did. Basically a very peaceful protest. And apparently that's witness intimidation, because the witnesses don't like being confronted with having to tell the truth, apparently. So they don't like that. And so Timothy Bradl has been representing him on this case. Well, he actually, because he wasn't even served the papers, he didn't even know that this was going to happen or that there would even be a hearing at this moment. So he happened to be at the courthouse for a completely unrelated case, and he gets noticed that they want to kick Turtleboy out of the courtroom. So, and Turtleboy is sitting in the back. You can't see him. He's next to this woman here. You'll see him. He's sitting right there. They'll zoom out, or they'll zoom in on him.
Does Mr. Carney want to sit with you?
I think he's okay right there.
Okay.
If that's all right, Your Honor.
All right. So, Commonwealth, so I do want to say a question before we begin. Commonwealth, in your motion to exclude an individual charged with witness intimidation in connection with this case from the courtroom during the testimony of certain witnesses, before we begin, are you advancing the concerns of the DA's office or the concerns of the witnesses themselves, or both?
Both, Your Honor.
Okay. So,
Both. Like, he doesn't represent the witnesses. So why is he taking it upon himself to basically protect all of these witnesses? Do you know what I'm saying? It doesn't make any freaking sense. And whether Aiden's in the courtroom or not, the witnesses should be able to tell the truth regardless. You know, if that's all they're doing is telling the truth, his presence in the courtroom shouldn't matter. They're going to be having a one-on-one with a lawyer, and Aiden shouldn't affect them one bit. But for some reason, the Commonwealth would rather put effort and time into the motions to get rid of Turtleboy. Again and again and again. They keep trying to take his rights away. And it's so freaking frustrating watching this from afar. I'm in Chicago just watching this, and I'm like, why are they doing this? It makes me angry for Turtleboy, because I don't like to see people get trampled on. And they keep piling it on with him, with adding more and more witness charges and more whatever they can get him with. Now they're trying to say he's conspiring with Karen Reed to witness intimidation. And it's just ridiculous. It's ridiculous. The lengths that the Commonwealth is going through to try to shut Turtleboy up. They can't shut him up. He's too effective. He's too good at what he's reporting on, and they don't like it. So here they are trying to kick him out of the courtroom altogether, which makes no sense. But all right, let's keep going.
If I may, I'm sorry to jump in, but just if I may, I do have what I think is a pretty substantial procedural objection.
Okay.
Maybe I'd ask that you sort of just make a quick clarification of the issues here, and we can address the procedural issue before we get into the substance of the motion.
sure, I'll hear you.
We could. Thank you very much, Your Honor. Your Honor, so the record is clear, because we may need an appellate record in this case.
Okay.
But I was here in the Norfolk Superior Court today, completely unrelated to Mr. Carney, my client, as you know, in the other matters. And I was here today on the matter of Commonwealth versus Tylee Curry for a motion to suppress.
Which is a case that I am in the middle of that motion to suppress with you.
Exactly. And I actually figured that we wouldn't do the motion and get a date. But I was fully focused on that matter and had no notice whatsoever that the Commonwealth was in the Reed matter, was seeking to exclude my client as a journalist from this courtroom. The first thing is that, and I know the court has a job to do in terms of ruling on this motion, and that's fine. And I ask that the ruling be that it be denied on procedural grounds. The procedural grounds are, Judge, that there's been no service of process whatsoever on a case where the government is seeking to essentially trample all over my client's First Amendment rights as a journalist. On 15 minutes notice. You know, I know you gave me the thing 15 or 20 minutes ago.
And it's more than a half an hour, but I understand.
All right, well, you get the point. So, you know, this is not.
Really, Judge? Really? He says 15, 20 minutes, and you say it was more than a half an hour. Like, that's sufficient timing. Are you kidding me? If any one of Karen's attorneys did that and didn't serve Lolly something, she would be up their butts so fast. But no, because Lolly did it, it's okay. I forgive him. I don't understand this courtroom. She, FYI, for those who don't know, they tried to get her recused. They tried to dismiss the whole DA's office and I believe Adam Lolly from the case completely. Just, you know, let's have some neutral eyes looking at this, but no, it's still stuck here in corrupt Norfolk County with corrupt Judge Bev Canoni. And that I'll stop interrupting, at least for now.
Not something that I can process and absorb and make any sort of cogent arguments on the merits of the motion on that time period. I'm sure that the court respects that. I'm trying to address it as best I can, but I think that the procedural issues here should control. And here's the procedural situation, Your Honor, that the government filed this 6-page motion. There's a footnote, too, that refers to them serving this motion on May 8th to the Associated Press. Why they couldn't just pull up my email and serve me is an open question that I'd like an answer to in open court. So they can serve the AP.
You can e-file now. You can e-file these documents with the court now, so there is no excuse why he didn't get a copy. No excuse.
2 days ago, but they can wait and not even serve me with the motion when I get here to court today on a completely unrelated matter, I might add. So there's some funny business going on here, and there's been nothing but funny business from where I sit from the Commonwealth on Mr. Carney's matters. And here we go again.
He has had it with them. I would too. Like he's tried cooperating, he's tried playing nice, and they don't want to play nice. They play dirty. They fight dirty. Ken Mello, who was the special prosecutor, now no more, but was the special prosecutor in this case against Aidan Carney, tried to come back and get Tim Bradl with some kind of misconduct or something. I don't know. And they wanted sanctions on him. It's like, really, bro? Like, you can't even turn over discovery, and all of your evidence is taken out of context. Words that he said on his YouTube channel. Ridiculous.
So I don't appreciate that from counsel.
Yeah, he's
from the
done.
Norfolk County DA's office, number one. Number two, Your Honor.
Remember, he had 20 minutes to prepare for this, but according to Canoni, it was 30. So he should be good. Don't worry. He had over 30 minutes.
Mr. Carney has covered this case and written about 350 news articles on this case. He has developed evidentiary scoops on this case that have added to the quantum of evidence in the matter.
Yes. The defense for Karen Reed has entered things into evidence that Aidan Carney has dug up. That is why the Commonwealth does not like him. That is why the Commonwealth hates him so much, because he's effective. He's good at his job. He's good at getting the answers. And people do want to talk to him. They do trust him. The Commonwealth, on the other hand, people do not trust the Commonwealth or the cops in this area, because there's been a long time corruption in Massachusetts, is what I'm hearing, like especially around the Boston area. And I think Canton's only about 45 minutes away from Boston. I think it's like a suburb sort of Boston. If I'm wrong, please let me know in the comments. I've never been to Massachusetts. I would love to, but I've just never had the opportunity. Anyways, all right, let's keep going here with Tim Bradl's spicy arguments here.
Never caused a problem. He wishes to be in the galley of journalists, like everyone else, and cover the case. There's never been a problem whatsoever. This is more personalized retaliation from the Norfolk County DA's office against Mr. Carney. Another point, Your Honor, is that this matter, as far as the Commonwealth is concerned, is res judicata times 2. Judge Krupp in this very court addressed this exact issue about Mr. Carney covering this matter, being in the courtroom with witnesses that had a stay-away order. All the same people that the government is trying to have another bite at the apple with here. All these people. This was adjudicated fully with the Special Assistant DA before Judge Krupp, and Judge Krupp ruled against the Commonwealth. Judge Krupp said that Mr. Carney was able to be in the courthouse covering this case regardless of any of these witnesses in the stay-away order.
Yep. He was excluded from the stay-away order at times when he's in the courthouse. So if the woman who has an RO against him if she showed up with it in her hand, ready to get him kicked out of the courtroom, it wouldn't work. He has now approval from the Supreme Court. They were trying to get the RO completely quashed, like removed. However, there's no legal precedent in history where that's ever happened, because no one's ever wanted an RO taken off, a restraining order taken off of them like that. So, and it's never happened. But the charges are bogus, and the woman who charged the files, or filed the charges, sorry, I believe she withdrew them. She's also attempted to continue to contact him, even though she has a restraining order on him, and it's just a whole mess. And she was obviously used by the DA's office to try to get Turtleboy thrown in prison, and that's she did what they needed, and they have no more use for her because he can go to court now. But now they have another reason why they have to get rid of Turtleboy. This is just insane, like the amount of abuse that they keep throwing at Turtleboy. But it's not just him, it's like everybody. It's the buffer zone, it's all of it. Like, if you really have nothing to hide, why are you doing this, Norfolk County? It makes no sense.
Stay away order was exempted from Mr. Carney's presence in the courtroom, rather, was accepted from the stay away order.
Okay.
So this is done. This has been adjudicated. It's been adjudicated again, Your Honor, by Judge Pomeroy across the street in the district court. One of these people associated with Mr. Carney's detractors, Ms. Gattani, has taken up with the Commonwealth and sought charges and sought a restraining order against my client. And Judge Pomeroy recently, as recently, I think it was a couple of weeks ago, we were across the street, Your Honor, seeking to vacate the order under the doctrine of unclean hands, because this plaintiff keeps trying to contact my client while under a restraining order. Putting that aside, the ruling in that matter, Judge, was another ruling in support of Mr. Carney's First Amendment rights. It was another ruling that said Mr. Carney was not subject to the restraining order in any court of the Commonwealth. And the reason we brought that motion, Your Honor, was because these same witnesses that the government here is, again, trying to advocate for their own personal issues, those same witnesses somehow took up with this plaintiff across the street, Ms. Gattani, brought her to court here in prior Reed proceedings to kick out Mr. Carney, because at the time she had an operative order against him. And Mr. Carney, to his credit, got up and left and got out of here. And that situation was what we addressed across the street with Judge Pomeroy. He agreed with us and said, you can go to court, you can cover this case. So number two, litigation number two, this has been established. Mr. Carney followed all proper channels. We worked with the SJC media office. He has a press pass. He's doing everything in accordance with all of the rules and regulations that are in place. He's been harassed, and we have it on video, by other so-called journalists on this case at the steps of the courthouse. And he just wants to be here. He doesn't want to be an issue in this case. He wants to sit here and cover the case. He's done his job. He wants to watch the trial unfold. And he has an absolute fundamental First Amendment right to do so within the confines of this courtroom and within the confines of time, place, and manner restrictions. He's followed everything, and he's here. We've gone through all of these hurdles, Your Honor, and Mr. Carney triumphed, as he should, because it's the First Amendment that needs to triumph here, not any particular person. And that's what he's doing. And there's absolutely no reason for the government to sneak behind my back to interfere with his First Amendment rights. It's outrageous, and on procedural grounds, I ask you to deny the motion for all of those reasons. And if the court has some hesitancy to do so with respect to these procedural issues, I ask that you set a date give me 7 days or so that I can properly respond to this motion on the merits of whatever's in these 6 pages of the motion that I haven't been able to look at. So thank you for hearing me, Your Honor.
All right, sure. And you wanted a response to your question from Mr. Lally on why you were not served, but the Associated Press was served.
That's correct.
So if you
I give Bev credit for that, because she could have let that go and not made Lally answer to this, but she's making him answer to this. Even though she doesn't hold its feet to the fire, like, for not serving the paper or, not filing it with Tim Bradl and notifying him, but at least she makes him answer for it.
Talk about that in the procedural part of this, Mr. Allen?
Yes, Your Honor. Simply put, Mr. Bradl, neither Mr. Bradl nor Mr. Kearney are parties to the case. I can't presume that Mr. Bradl's representation on one criminal case is going to extend to a motion of which he would be at best a third party on a separate criminal case. We are required under the SJC rules to serve it upon the Associated Press, which we did.
So I think that's your record now, Mr. Bradl?
We didn't know if Tim Bradl was representing him for this particular motion, so we didn't give it to Tim Bradl. What? But we still gave it to the Associated Press as required. You're also required to notify the other attorney. And he is Aiden's attorney on record with the Norfolk County District. Like, I don't know why that's difficult for them to understand. But anyways, that's the reason.
Thank you.
Okay, on the procedural issue, okay? We have a jury out. I do want to address the merits of this as best we can. And Mr. Bradl, at the end of this hearing, whatever I end up doing, if you want to come back and readdress it when there's more time, depending on how I rule, I'll give you the opportunity to do so. But I have to get this trial moving.
Depending on how I rule. Yeah, you already made up your mind, Bev. You don't need to sugarcoat it.
At this point, one way or the other. So I'm going to hear the Commonwealth on their motion. Then I'll hear you, Mr. Bradl, to the extent that you can respond, okay? All right. Mr. Lally, I'll hear you on your motion.
Your Honor, very shortly, very simply put, this is an instance in which the Commonwealth is not asking that Mr. Kearney not be allowed to cover the case or that he not be allowed to watch the trial. What we're requesting is a partial closure of one individual. And the legal standard for that is essentially a substantial reason. Substantial reason, Your Honor, being that Mr. Kearney has been indicted and has open cases for intimidating witnesses, specifically witnesses in this case. He has confirmed statements indicating public.
Charges are not a conviction. Charges don't mean anything when you can literally indict a ham sandwich in the Supreme or in grand juries. Sorry, I couldn't think of the word for a second there.
Publicly that his actions that he's taken in regard to those indictments were to prevent the case from ever going to trial and to intimidate those witnesses. Those witnesses will be called to testify in this case, and what the Commonwealth is simply requesting is that he be excluded physically from the courtroom, not excluded from watching the trial, not excluded from covering the trial, but excluded physically from the courtroom while those witnesses are testifying from the stand.
And the witnesses you told me have expressed concern. What do you say about that?
Yes, Your Honor. The witnesses have expressed concern. The Commonwealth is concerned as to his presence affecting their testimony or their ability to recall. And for all of those reasons, the Commonwealth would submit the administration of justice and the witnesses being able to testify, as well as the witnesses' own concerns are more than meet the test of the substantial reason for Mr. Kearney's exclusion during the course of their testimony.
Okay. Mr. Bradl?
Your Honor, the witness's concern has no legal materiality.
Damn
under
straight.
the law. So the answer that I have is, so what?
She's not
The
even
witness's
listening.
concern, where does that fit into the law here, Your Honor? This matter has been adjudicated twice. Mr. Kearney has the right to speak on the case. He's gone through all the proper channels to be here. He is not in any way wants to or is trying to make any issue of his presence here, and he's just trying.
He's not a danger. He's not a threat. The only way that he threatens these people is by exposing them for what they've done and who they are. That's the only threat. And if that's the only threat, well then, that's not. It's such an abuse of power that they use this witness intimidation statute, which is already unconstitutional, by the way. And then just try to get him with witness intimidation. It makes no... these people make me mad.
Trying to cover the case as best he can. And this is just a personal vendetta that's been carried out by the Norfolk County DA's office against Mr. Kearney. And, you know, this is where the court needs to hold the line on the First Amendment. You know, this witness intimidation statute, Your Honor, is an absolute abomination. It is going to be struck down. It's just a matter of time. And this is just a continuation of everything the special counsel's been doing to Mr. Carney, and now the office itself is doing it. There's no reason for this motion to be allowed, Your Honor. There's no discomfort exception to the First Amendment, Your Honor. There's been absolutely nothing advanced, especially on an emergency basis, which is, I assume, why this is being done with no notice. There's been no establishment of any emergency. There's been no conduct whatsoever on the part of Mr. Carney to justify this motion. And I did happen to see some reference to the Chestnut trial about published, it's something to the effect of doxing a seated juror. That is false. Mr. Carney wrote a story on a juror after the jury was discharged. There's absolutely no prohibition or problem or issue with that.
The Commonwealth loves to lie and to spin things to make other people look bad, and they blatantly lie about people. That's defamation. How do you stop it? How do you stop a whole county from defaming people?
That. And it is absolutely protected conduct by the First Amendment. And it is not in any way a grounds for this court or the Commonwealth to assert any wrongdoing against him.
So I can assure you I am not considering that incident in this. You all know I was the judge. I am not considering that experience in this motion.
Thank you, Your Honor.
Anything further, Mr.
Nothing further.
Bradl?
Thank you.
All right. So, Mr. Bradl, I agree with you that Mr. Kearney has certified, is certified by the Office of Public Information pursuant to SJC Rule 119, and that he has a right to be here today. He arrived timely, and that he is registered. I have honored that 119 registration today, and I will continue to honor that. However, my role in this case, Commonwealth versus Karen Reed, is to assure that the defendant's constitutional right to a fair trial are honored and upheld. And because of the chilling effect that Mr. Kearney's presence, I find, will have on the witness's testimony, I'm going to excuse him while the named witnesses in the Commonwealth's motion.
What does that even mean? The chilling effect that he has on the witnesses. What legal grounds is that? The chilling effect he has? What is that? What does that mean?
Julie Nagel, Christopher Albert, Colin Albert, Michael Proctor, Jennifer McCabe, Matthew McCabe, Brian Albert, and Yuri Buchanek. And the Commonwealth also today requested Nicole Albert because of the incidents that reportedly have been held at her home.
Oh, what happened? What's going on? Hello? The page just stopped working. Well, that was pretty much it.
Disorder.
Anyways, oh, here.
That seat will remain empty. No other person of the media will be able to take that seat in his absence. Okay?
Your Honor, one last thing, if I may, just came to me as I was standing here. Extension in the same regard as to Nicole Albert for the address would be Brian Albert Jr., son of Brian and Nicole Albert, lives in the same address.
It's for the same reason, so Brian Albert Jr. All right, so those are my findings, Mr. Bradl.
So he can't be in the courtroom. He can still be in the courtroom for other witnesses except for the people that she listed. So it's basically all of the witnesses, all of the people that were in the Albert home that night that we want to hear from, every single one of them. Yeah, they're on the witness list. Like, what? He didn't intimidate every single one of them. He just wants them to come out and tell the truth, and that's all he's ever asked. So this is so bogus. And then she's like, well, you can appeal it. Like, yeah, damn straight I'm going to appeal it. Because you're corrupt. All right. Sorry. Let's move on to the actual motion. So this is the... I have that twice now. Okay. I don't know. I've been messing around with stuff, so anyways. That looks good. Alright, we can actually probably go a little bit bigger so you guys can see. Alright. Center. All right. Okay. Stop it. All right. I was just being annoying. All right, so this is the Commonwealth's motion to exclude an individual charged with witness intimidation in connection with this case from the courtroom during the testimony of certain witnesses. Now comes the Commonwealth and moves that this court excludes Aidan Carney from the courtroom during portions of the ongoing criminal trial of Karen Reed. On December 20th, 2023, Carney was indicted by a Norfolk County grand jury for 16 criminal charges related to allegations of his intimidation of witnesses. Okay, yeah, allegations of his intimidation to witnesses who will be called to testify at this trial. See the docket, whatever. As extensively detailed in the Commonwealth's opposition to defendant motion for sanctions and for disqualification of the Norfolk County District Attorney, the Commonwealth asserts that the defendant and her counsel colluded with, directed, and encouraged Carney to attack witnesses to embarrass, intimidate, and deter those witnesses from testifying in the trial. No one's deterring witnesses from testifying. We want them to testify. We want to hear what they have to say. Who's deterring anybody from, or trying to intimidate anybody from trial? No, that's the opposite. We want them to take the stand, and we want them to answer for their comings and goings that night. We want to know. Anyways, oh, there's a big footnote. I can't read that writing here. All right, so the Commonwealth relies upon and incorporates by reference the facts and arguments articulated in the Commonwealth's opposition to defendant's motion for sanctions and disqualification. All right, in the time leading up to trial, Carney repeatedly publicly insulted and disparaged the prosecution, the trial judge, witnesses, and the victim's family who are in attendance at the trial. It's not against the law to do that. Newsflash. He has every right to have said the things that he said. And it's not necessarily disparaging if it didn't happen. If they didn't actually do what we all know they did in that house. So, there's that. All right, and I apologize. This is really hard for me to read, so I'm going to do the best I can. An open courtroom enhances, this was like a picture, I think somebody took a picture of the document and put it online, and that's what I got. So, an open courtroom enhances both the basic fairness of the criminal trial and the appearance of fairness. So essential to public confidence in the system. However, the right to a public trial is not absolute, and in limited circumstances, a court may bar spectators. Sorry, this is really fuzzy. May bar spectators from certain portions of a criminal trial. When there is a partial closure, it is necessary to show only a substantial reason rather than an overriding interest to justify the closing. The partial closure also must be no broader than necessary. The trial judge must consider reasonable alternatives to closing the proceeding, and the trial judge make adequate findings to support the closure. What does that say? The Commonwealth also suggests that there is a viable argument that the barring of one spectator from being in the courtroom during the testimonies of persons he is alleged to have intimidated would be a demonami closure, particularly where there is a remote access to WebEx online platform. What, so we could do is online streaming? What is that term? I would tell you if my phone would cooperate. De minimis. Like, all right, never mind. De minimis.
De minimis.
Oh, I did say it right.
De minimis.
Too trivial or minor to merit. Too trivial or minor to merit consideration, especially in the law. All right, so I don't know how that fits into that sentence, but okay. During testimonies of persons he is alleged to have intimidated, would be de minimis closure. The Commonwealth moves for an order excluding Carney from the courtroom when the named victims of the indictments charging him with witness intimidation testify. That's Julie Nagel, Christopher Albert, Colin Albert, Michael Proctor, the lead investigator of the case. He's not intimidated. These people aren't intimidated. They're scared of Turtleboy's journalism because it's effective. Brian Albert and Yuri Buchanek. Carney has traveled to and confronted these individuals at their homes, workplaces, children's sporting events, have called them murderers, and has repeatedly filmed and confronted these individuals as they attended prior court proceedings. Nothing he did was illegal, and everything he did was in the name of journalism. So I don't really care what the Commonwealth has to say. All right, so see generally SJC Rule 119 2A. A judge may limit or temporarily suspend such access by the news media if it appears that such coverage will create a substantial likelihood of harm to any person or other serious harmful consequence. So you're saying you could, if you wanted to, limit or suspend Turtleboy from writing about this case? Is that what they're trying to say there? In addition to intimidating these witnesses and engaging in conduct to deter them from testifying at the defendant's trial. No, buddy, no. He's not trying to deter anybody. He's trying to get them to testify and tell the truth. In addition to intimidating these witnesses and engaging in conduct to deter them from testifying at the defendant's trial, Carney has publicly engaged in aggressive personal attacks against the character of these individuals and their family members, some of whom will be testifying. Oh no, we might hurt people's feelings? Is that what this is about? I mean, seriously. Carney has also used his social media platforms and website to sell different types of merchandise and clothing, promoting his interpretation of the evidence, supporting the defendant and her attorneys, and mocking the witnesses he is charged with intimidating. There's nothing against mocking people. Like, there's nothing against the law of mocking someone. It's not intimidating them. Mocking someone is not the same as intimidating. All right, and others connected with the case by using their names and photographs in his merchandise. What names have they used in his, or what names or photographs has he used other than his own mugshot when he was arrested? I don't think he has any merchandise with people. I don't know. I mean, I don't know everything he sells, but I know there's the House Long to Die in Cold shirt. It's like the Google and it, you know, in the bar, but that's the only thing I can think of. And again, like, what are your legal grounds? Because he's saying things you don't like. So in the end, you're still just trying to suppress him because he's saying things that are against the Commonwealth. It's ridiculous. Notably, a number of these witnesses, while not named victims in Carney's complaints, reside in the homes Carney picketed at and have been detrimentally affected by his criminal conduct. Really? How? Get over it. If these people did what they did, which we all know they did, then their lives should be effectively changed. And we should be digging up the truth and not burying it and trying to have some sham of a trial for a woman who is clearly 100% factually innocent, and the Commonwealth still just denies all of their wrongdoing. It's ridiculous, but sorry. I mean, I could just go on and on about this, and I have, so I'll shut up. All right, so Carney picketed those people. Additionally, on May 9th, 2024, while Julie Albert was testifying, Carney published a 2021 text message of his social media page that contained a communication from John O'Keefe's cell phone and Julie Albert. Prior to trial, no communications from John O'Keefe's cell phone had been made public and only provided to defense in discovery. Public now. What you gonna do? It's ridiculous. Why can't we report on the truth? Why can't he talk about what's really going on in this county? They just try to keep shutting him up. All right, so the Commonwealth. Did I finish the sentence? I think so. Yeah. All right. So the Commonwealth also raises concerns for the safety of the jurors as their identities are impounded, and pursuant to an earlier court order, the media is prohibited from filming or photographing any juror. In July 2023, Carney doxed a seated juror by publishing her personal identifying information, photographs, and videos with a malicious intent following a mistrial in Commonwealth versus Emmanuel Lopez. And that's what Bradl was saying in his arguments, that this is an outright lie. He interviewed the juror after the case was completed, and it was his right to do so. And she willingly gave the interview and photographs and everything. You know, I mean, there was no malicious intent. Notably, Judge Cannoni was also the trial judge in Lopez. A judge may impose other limitations on the media necessary to protect the right of any party to a fair trial or the safety and well-being of any party, witness, or juror, or to avoid unduly distracting participants or detracting from the dignity and decorum of the proceedings. But was Turtleboy bothering anybody? The only one bothering people there is the one whose name I don't even want to say because I don't want him coming after me. But that guy who is giving Turtleboy the most trouble. It's ridiculous. I can't even believe my eyes of what's happening in this world right now. All right, so discussing a judge's authority under blah, blah, blah. We give careful attention to the evaluation of a trial judge, especially one who, as here, presides in the county where the crime occurred and is familiar with the nature and pervasiveness of the pre-trial publicity. Like, how is this? That's barely relevant. All right, so we have granted trial judges wide discretion in dealing with publicity that might have a prejudicial effect on jurors. How is Aiden sitting in the courtroom having a prejudicial effect on the jurors? That makes no sense. This is totally irrelevant. While an atmosphere of tension is difficult to describe, trial judges routinely must gauge the tension in a courtroom and the dangers it poses. Family and friends of the defendant and the victim divided into actively antagonistic factions, requiring court action to maintain control of courtroom. But the courtroom's not out of control. Aiden wasn't doing anything outside of the court's decorum rules. So there's absolutely no reason why he had to leave. She had no grounds for kicking him out, but whatever. A judge's responsibility for the safety, security, and integrity of the courtroom requires an acute attention and an appropriate response to the risks of violence and intimidation. That response may be proactive as well as reactive. Commonwealth versus Fernandez. and also Maldonado. On appeal, deference is owed to a trial judge's perception of the dangers of threats and intimidation in the courtroom. A judge need not wait for a witness to be intimidated, the courtroom to be disrupted, or a specific threat before taking appropriate steps to address the risk of such misconduct. I got you, but again, like, he was not doing anything. And how is he intimidating witnesses when he's just sitting in a room behind a laptop typing? I mean, how's that intimidating to a witness when they're supposed to be focused on answering the questions in front of them? And the lawyer, they're supposed to be focused on the attorney asking the questions and giving an honest response. But whatever. Alleged witness intimidation by suspected gang members and courtroom disruption gave rise to an article. What? Why does... Man, I always am reading along and then there's just like a word that totally throws me. And there's so many big words in these documents that I don't know. Articulable? I can't pronounce that. Let's get it. Capable of being expressed, explained, or justified. I don't have I can't press the button. Articulable. Articulable? Articulable. That's hard to say. Articulable, I think. I don't know. Don't take my word for it. Anyways, yeah. So that's what that means. So an alleged witness intimidation by suspected gang members and courtroom disruption gave rise to an articulable risk that justified trial court's order requiring trial spectators to provide identification as condition of entry into courtroom. Why is that in here, Lolly? Like, why? I don't understand. It's not really relevant. All right, this case has presented significant security issues and has resulted in a 200-foot buffer zone, only because you people are unconstitutional and want to shut people up, including Judge Bev, because she's the one that approved it. So the 200-foot buffer zone surrounding the Norfolk Superior Court and the daily deployment of the Massachusetts State Police and Dedham Police to maintain order outside of the courthouse. Furthermore, the case has necessitated additional uniformed court officers and trial court security to be present in the courtroom and courthouse. The trial judge has discretion to take into account special circumstances like security concerns to protect courtroom and its occupants. Whoops, I think did I skip a page, or was this? I don't know. I only got 5-6 pages, so something is cut out because this starts off in the middle of a sentence. Alright, so whatever. I think we read that though. Clemente. Didn't we read this? We read this, so that's a duplicate page. Alright, so that's pretty much it then. Or that is it. I feel like we're missing a page. Maybe Aiden put in the same page twice, or I did the wrong thing. I don't know. I don't know what happened, but we're missing a page there. Anyways, so yeah, this is wild. What do you think about this ridiculous parade? Like, it's like a circus. It's a circus that the Commonwealth is making of this case. The Commonwealth is doing this by making basically you're going to make Turtleboy a martyr for everything he's done for the Karen Reed movement. So thanks for that, because he's famous now and everybody's subscribing to him and wanting to know who's this reporter that got kicked out of the Karen Reed trial. Everyone's going to know now. Everyone's going to know Turtleboy, and they're all going to be reading his blog. So thank you, Commonwealth, for that, because now they're going to know what's really happening. It's crazy. The balls that the Commonwealth has. I mean, the whole world is watching you guys right now. And this is the shenanigan shit that you pull. I mean, come on. Who cares if Aiden's in the courtroom or not? Like Tim Bradl said, the way that the witnesses feel is immaterial. It is the First Amendment right for Aiden to be there, and that supersedes the witnesses' right to be in a courtroom without him, which really isn't a right. So, I mean, I don't know. It's just wild, the balls that these people have. Let me know what you guys think in the comments below. Tell me what has you the most shocked by what the Commonwealth has done. I think the most shocking to me, probably the whole Aiden arrest and getting, the whole Lindsay Gattani thing where she got him arrested, let's say, rather, and took him to court for the restraining order and all this. Like, that felt defeating when that happened. But I can't believe that he stuck it out for 60 days. He could have pled at any time to come home and see his kids. He was away from his kids for 60 days trying to fight his First Amendment rights. And you better believe that they are appealing this. And this isn't over. This conversation isn't over. This story isn't over. Turtleboy is going to be rich and famous one day. You guys just wait. I mean, he deserves it for the 60 days he spent in jail for it. Like, see, he spent 60 days in prison for this story, and you guys still are like, now he's out, but you still don't want him there. So it really shows your pettiness, and it shows that there's something there. There's a there into this conspiracy cover-up theory. I mean, I already fully believe it, but if I didn't, and to people who didn't know it, they're now thinking, oh, that's weird. Why are they trying to get rid of this blogger, reporter guy who reports on this case? And then they look into him and see. It's crazy. All they're doing is making a household name for Turtleboy. What is a Turtleboy? I don't know. I didn't figure it out until I saw him on court TV one day. Way back when, sometime probably about a year ago-ish. Right around a year ago now. And that's when I found him talking about this case. So he's done everything for this case, and he deserves the praise. So, and all the other people out there standing there, holding signs, and being part of the movement. So I thank you guys for being a part of the movement, because just watching and learning about this case is helping to bring these horrible realities to light, that it can happen in any town, USA. Karen Smith, Karen Jones, Karen whoever, Jim Jones, whoever it is, John Doe, they could all be in Karen's position, because it's just so easily manipulated. Especially if you're in the system, like a law enforcement trooper for the Massachusetts State Police, let's say, you can just use your power and wait and make the problems go away and frame an innocent woman. So that's what I believe he did. Sick. All right. Well, you guys, I can't wait to see Proctor if he does come to the stand. He's gonna be amazing. It's It'd be a great cross. Anyways, I will let you guys go. Thank you so much for watching. I hope that you enjoyed this one, and I will see you in the next one. Take care, guys. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or someone you know wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.